Imagine being hit by a drunk driver. Fortunately, you walk away with just some minor bruises and maybe a sprain. But what most people don't realize is that even with minor injuries, there can still be significant legal consequences for the driver that caused it. In Virginia, that kind of reckless behavior can open the door for punitive damages, which are designed to punish and send a message that drunk driving will not be tolerated. I'm Ryan Wynn with Wynn Injury Law in Richmond, Virginia. Our firm represents victims of car accidents, including DUI crashes, and helps them get the compensation they deserve. Today I want to share a recent case that shows how a minor injury can still qualify for punitive damages, and why that matters for victims and their families. Let me tell you about one of our cases. My client, who was a young girl at the time, was driving home with her mom when they were rear-ended by another vehicle. It turns out that driver was over 3 times the legal limit. That driver's BAC was .28. Fortunately, the young girl was not seriously injured. She went to the emergency room and followed up with her pediatrician, but within a month had made a full recovery. During the course of the case, we learned that the defendant had a prior DUI. Even though the young lady suffered minor injuries and was fine within a month, we were still able to achieve a 6-figure settlement because of the punitive damages claim. In Virginia, punitive damages are governed by Virginia Code Section 8.01-44.5. Here's what that means. If the at-fault driver has a blood alcohol content of 0.15 or higher at the time of the accident, or unreasonably refuses to take a blood alcohol content test after the crash, or acted with malice or conscious disregard for others' safety, then you may be entitled to punitive damages in addition to compensatory damages. The goal is not just to help the victim recover, it's to punish reckless conduct and to deter others from making the same dangerous choices. Punitive damages in Virginia are capped at $350,000, but they're separate from compensatory damages that covers things such as medical bills, lost wages, and pain and suffering. Obtaining these damages requires strong evidence. This includes police photos and videos, witness accounts, and the results of blood alcohol content testing at the scene. That's where having a lawyer really matters. We know what to look for and how to build a case to show that the driver's conduct was not just careless, it was reckless. If a drunk driver has caused harm to you or someone you love, even if your injuries are minor, don't assume you do not have a case. Virginia law protects victims in these situations, and punitive damages plays a big role in holding reckless drivers accountable. At Wynn Injury Law, we're here to help you understand your options and fight for what's right. If you found this video helpful, please like, subscribe, and share it with someone that may need the information. And if you need guidance after a DUI crash, please reach out and we'll walk you through every step. We are Wynn Law, and we are here for you, Virginia.